As the proceedings take place, Sammy Douglas has already tabled an apology. Obviously, members, at our meeting on the 12th of November, we considered the stocktake report on the implementation of the Roe House Agreement that was completed by the Roe House assessors and the Northern Ireland Prison Service response to the comments made in respect of compliance. And we did agree for an oral evidence session with assessors and the Director General of the Prison Service to be scheduled to discuss the report and the response. The Roe House assessors are here to attend today's meeting to discuss their stocktake report, and the relevant papers are in pages 7 to 19 of your meeting folder. Let me formally welcome Peter Bunting, Reverend Dr Leslie Carroll, Mr Chris McCabe and Mr Conal McFeely to the meeting. You're all very welcome. As normal protocol would be, we'll record this by Hansard and that will be published in due course. First, let me apologise for the delay in getting proceedings started. The Minister for Health was making a statement in respect of child sexual exploitation, which is an area that the committee has considered, and it was important for that statement to be heard, and I had a question to table in respect of that as well. So my apologies for the delay in getting this meeting commenced, and hopefully we'll be able to get through it as quickly as possible. So I'm going to hand over to yourselves at this stage. I think it's Mr Bunting.
No, we're going to ask. Sorry, Chair.
Sure.
The Reverend Leslie Carroll is going to issue a brief statement on our behalf, then we'll take questions and answers.
Okay.
Thank you, Chair. We thought it would be helpful just to give a brief overview of how we got to where we got to in the report and how we were appointed, and some of the key points then in our stocktake. So in August 2010, the agreement was signed between the prisoners in Row 3 and 4 and the prison governor at Maghaberry Prison on behalf of the prison service. The process of reaching agreement was led by the Joint Facilitation Group and aimed at resolving a dispute between prisoners and prison authorities. It was further aimed at creating the pathway for a prison regime predicated on the principles of mutual respect, safety, human rights and equality. In this respect, it was agreed that all staff should be able to carry out their duties free from harm, intimidation or threat, and that both the public and prisoners should have confidence in the Northern Ireland Prison Service. Following the signing of the Roe House Agreement, 4 independent assessors, that's us, were appointed to assist in the oversight and delivery of the agreement. Over the 4 years since the agreement was signed, we as assessors have seen significant challenges to the implementation and embedding of the agreement, and we acknowledge these in our stocktake report, setting them out as the callous murder of prison officer David Black, the most egregious breach of the principles underpinning the agreement, a widespread perception amongst the prisoners and the that the prison service are not fully committed to the agreement, and a breakdown in relationships and confidence between prisoners and the service, and a lengthy dirty protest which took its toll on staff, prisoners and management. In June of this year, the Prisoner Ombudsman recommended to the Minister that a stocktake of the implementation of the agreement should be carried out, and in July the Minister provided terms of reference to us as independent assessors to carry out that stocktake. We were invited to, quote, return to the agreed principles and undertakings of that agreement and pass comment on the state of compliance. We were granted access to all Maghaberry staff, prisoners of Row 3 and 4, and provided with documentation including prison policies, minutes of forum meetings, ombudsman reports, communication records and CCTV footage in relation to search procedures. In the process of the stocktake, we examined all documentation provided to us, viewed CCTV footage and met with a wide variety of people to assess implementation across areas agreed in August 2010 and to pinpoint any other issues that had come to the fore in the interim period. This wide evidence base enabled us to formulate conclusions. So the issues addressed in the stocktake and agreed for progress in August 2010 were prisoner forums, search arrangements, controlled movement and association. Additionally, issues which had come to light over the 4-year period and which were of concern to prisoners and management, visiting arrangements, search policies, education and craftwork provision, criteria for prisoners being placed in protective custody, and doubling up in cells more appropriately designed for one Category A prisoner. We've made a number of recommendations that the Prison Service have responded to and will speak to for themselves, and we welcome their positive response. We are clear that not all the principles of the August 2010 agreement have been adhered to or acted upon, and that there are still serious trust issues between staff and prisoners, not least because of concerns about staff safety. We are also clear that the Row House Agreement offers a recognised opportunity for increasing trust and developing a safe, conflict-free environment in Row House. We do not underestimate the difficulties arising from separated arrangements, which remain a reserved matter and therefore for the NIO. But we are convinced that the opportunity to resolve the outstanding matters exists, thus ensuring full compliance with the principles and undertakings of the agreement. This will take an agreed timeline during which confidence and trust can be built, all threats, internal and external, should cease, and the prisoner forums begin to function effectively. We share with the Northern Ireland Prison Service and the prisoners a vision for the embedding of a prison system that is safe, humane and effective. Our stocktake report is before you, and we will be pleased to answer any questions regarding that report or the process by which we reached our conclusions.
Reverend Carroll, can I thank you very much for that? Just for some clarity, you four were appointed after the August 2010 agreement. Were any of you party to the negotiations that took place in arriving at the 2010 agreement?
Yes, Conal and I were.
Okay. And in terms of the involvement pre-2010, can you elaborate who was it that asked you to be involved in that process? Prison Service, or was that from the Minister? How did you get involved? I know the Irish Congress of Trade Unions were involved.
No, we became involved because we saw it was a very difficult situation, and we saw a situation which could get out of hand, which could develop across our society, which would lead to more violence, both outside the prison and inside the prison. And we took an initiative as regards to attempting to resolve the matter. But again, I wish to stress at all times we did it on what we thought was the best for Northern Ireland society, and it was done on the basis of safety for the prison officers and the prison staff, retain the security of the establishment, in other words, of the prison itself should not be diluted, and it was an attempt to get a resolution of very difficult situations which had culminated at that particular stage of an ongoing dirty protest by the prisoners, which was in many senses, I think, a health hazard as well, and as a health and safety matter for both the prisoners and indeed, more importantly, the prison staff. And we believed that what we were doing was intervening in a difficult situation. It does not, and we never have, agreed with the actions of the prisoners. In fact, we're on record, and I'm certainly on record, on many times of holding protests against the murder of the two soldiers at Mazarine, at the murder of Stephen Carroll. I held a public protest about that. I held a further one then against the murder of Constable Ronan Kerr, and I also then held a rally against the murder of Prison Officer Black. So, in all cases, I have condemned the prisoners publicly, and indeed eye to eye in the prison, which is probably more important and more realistic and pragmatic than condemning them in the newspaper, that at least I have, and so has Conal, and so has this particular team, without equivocation, have met those people in the jail, looked at them solidly in the eye, condemned their behaviour, condemned the murder of David Black, and at all times stated that if you don't agree with those principles come first, and after that then becomes an attempt to build the trust between the prisoners and the prison officers.
The joint facilitation group, you, Peter, were there from the Irish Congress of Trade Unions. Conal, who were you representing?
I, at that stage, was representing an organisation, a social enterprise from the community sector called Craken Enterprises.
Okay. And subsequent then to the 2010 agreement, the Minister appointed, or was it the Prison Service appointed each four of you to be the formal independent assessors of that agreement?
The Minister of
Okay.
Justice.
And in getting to the 2010 agreement, this initiative you talked about, Peter, and taking it forward, was that an initiative that you went to the Prison Service or the Minister and said, here's where we think we could be involved to come up with a solution that, in your view, would help? And this agreement was signed off by, was it yourselves were the authority to say, here's the agreement and we're signing off on it? Or was that the Prison Service signed off on it? Or was it Prison Service and the Justice Minister signed off on it? Because I want to get, first of all, establish who is the actual authority behind this agreement, because everyone can have a view as to what an agreement should be, and people can have a different view as to the solution. But ultimately, there are decision makers who take the decisions, and they're the ones in authority to hold to account.
We were initially, when Peter came forward and ourselves came forward with the view to try to help the situation, we were initially invited in by the Prison Service itself, and we obviously had conversation with the Prison Service, and based on that, they felt that we could obviously assist in that particular difficult situation at that particular time.
It was actually signed off, by the way, which is probably for the first time in the history of conflict between, in Northern Ireland history now, between prisoners and the Prison Service. It was signed by the Governor on behalf of the Prison Service and by each individual prisoner, who there were 28 of them, if my memory serves me right. There's obviously a time delay in some of this from 2010 to 2014, so it may not be totally accurate, Chair, but it was signed off certainly by the Governor of Maghaberry, who personally signed the agreement, what's termed now the 2010 agreement, and each individual prisoner.
And do you regard the 2010 agreement as being endorsed by the Department of Justice as well? Obviously, the Minister has commented extensively on it, but has this been given the formal imprimatur of the Justice Minister?
But I'm not sure that the Justice Minister was there at that particular time, was he?
He was, yeah.
He was. Well, certainly we did not negotiate at that time with the actual Minister of Justice. We did negotiate with, I think, the Director of the Prison Service then was Robin Maysfield. We had side conferences certainly with himself and with representatives of the Minister. But the Minister himself, I don't think, personally became involved, and to the extent that he was involved in negotiations. He was never involved in negotiations. All the negotiations actually took place either within Maghaberry, the confines of Maghaberry Prison, or indeed then latterly was Hillsbury Castle, if I recall correctly.
What the Minister did do once the agreement was signed and the actual dispute ended at that particular time, that particular dirty protest, I think that not only did the Minister but everybody across wider civil society welcomed the report and supported the particular report, because it actually was defusing a very, very volatile situation which also could have spilled out onto the street.
So, from the assessor's point of view, you're under the clear understanding that the Minister both welcomes and supports this agreement?
No, sorry, Chair. You're talking about the current one?
Well,
Well, you see,
the current stock.
Well, both Reverend Carl and Chris were not involved in that initial one. The two remaining people are Connell and I. After that, then the assessors, because then, as you're quite aware, things broke down and we had another protest in the prison where the prisoners wrecked the place, another cost to the taxpayer. So it was an attempt then, we went back to try, because we thought that we had certainly got the bones of a way forward, a pathway of progress, which would protect the safety and security of the prison, which would protect the prison staff, and then would get some rights to the prisoners, whereby they could get into an atmosphere of what we would term a conflict-free zone, where you could attempt to build some degree of trust, which would eliminate then the threats internally and externally to both the prison staff who are in Maghaberry, and then other people who would be involved in the Department of Justice.
Can I add a little clarity regarding the appointment of Leslie Carroll and myself? It was clear to me in the letter that I received from the Minister, from David Ford, that I was being appointed to do the job we're doing back in 2010 to assess an agreement that he endorsed. His letter made that. The fact that the letter came, it didn't say, there was no equivocation in that letter. It was a clear appointment to something that was now an up and running process.
Okay, well that's useful, and so I think it's important that we have that on the record. In terms then of the agreement that was reached in 2010, and Peter, you've touched on it, that it was then breached, and actually breached pretty significantly when you consider David Black's murder, you consider the dirty protest that took place, you consider how the officers that were working in Roe House, some of whom, indeed most of whom, when they would leave from having done their duty, were saturated in urine that had been thrown over them. It was flagrantly breached by the prisoners, and staff have been subject, which you acknowledge in your report, ongoing abuse of staff, threats to staff, 2 viable parcel bombs. Several staff have had to relocate to their homes. There have been threats on social media against named officers, both past and present officers. So, given the flagrant breach on the part of prisoners, how could you come to find in this report to make recommendations that would reward bad behaviour?
Well, I suppose the answer to that, Chair, is very simple. If we didn't go along, or we had accepted 2010 agreement as the basis for delivering on a conflict-free prison zone, again, I have to be very careful, because I'm not attempting to apportion culpability. There were ongoing difficulties, obviously, between the prison officers and the prisoners. Sometimes it's very difficult, and you know and I know that it gets murky and dirty within some of those situations, as you know it. We still believed that there was an opportunity to create that environment there, so that the prison officers wouldn't have to go through what you're after describing. It wasn't a matter of rewarding good behaviour. It was a matter of trying to get to a situation of which both staff and everyone else involved could live with, so that everything ends, that there is a conflict-free zone. Because to not to talk to people, or not to attempt to resolve the difficulties there, is like turning a blind eye. And if we weren't involved, I often wonder, for example, could we have a continuation of threats against prison officers? Because I'm sure you would agree with me, Chair, and I'm sure this committee would agree with me, the last thing we want is another dead body of a prison officer. And to that end, I believe that those of us in this society, and those of us who involved ourselves in quite a very difficult task, I may add, a very unsavoury task at sometimes, quite a robust, is the parliamentary polite language to put it, with the prisoners, was to ensure that the workers in the prison and that the prisoners do not have to go through these scenarios time after time after time. And is it not better that people like us attempt to put forward on behalf of society and get a resolution to the ongoing situation? And the other thing, Chair, which I want to emphasise as well, you know and I know what the Republican psyche or the nationalist psyche or whatever psyche we is, whatever we would like to call it, that when things happen in prisons, it gives a certain degree of oxygen on the outside. I hesitate to use the phrase, but probably the best phrase is martyrdom to a certain extent or whatever. None of us want that again. So isn't it better, surely, that people like us attempt to put our own time and our own effort in an unsavoury task to put ourselves forward to bring about a resolution which creates, without any dilution whatsoever, of the security of the prison, and I keep coming back to this health and safety of the workers there, and at least getting the prisoners into a type of regime where they can live with it without having any further excuses to engage in behaviour which costs the taxpayers as well of Northern Ireland huge sums of money, which are diverting finances from health, education and what we're all struggling in the austerity, to this time of austerity in Northern Ireland, to overcome.
Well, I don't for 1 minute question the sincerity of all four of you as individuals in terms of wanting to reach that conflict-free zones, but you're sincerely wrong. You're sincerely wrong in the tactics that are deployed, because if that was the intention, you failed miserably in August 2010, because David Black was killed in 2012, 2 years after the agreement that two of the individuals in front of me today were responsible for negotiating. 4 years after the agreement, of which all four of you were involved as independent assessors, those threats continue to this very day. The targeting, direct abuse of staff continue to this very day. So I don't question the sincerity. Indeed, I would uphold your right to try and put forward solutions as you see it. It'll be for those in authority who will be up next who need to answer me as to why they accept your sincerely wrong view to take this forward. And they're the people that I'll hold to account in terms of that, both at Director General level and the Minister, because ultimately they sign off on the work that you do. But the efforts that have been brought forward are a repetition of exactly the same philosophy that has dominated Northern Ireland's troubles and terrorists being in prison from the 1970s throughout. And all you do is encourage them to ask for more, to seek more concessions and reward their bad behaviour. That's what you're doing, and I would respectfully suggest to you that you are sincerely wrong in the approach that you're taking.
And I would respectfully say back to yourself, Chair, in terms of our engagement with the staff, the POA, the Governors Association and with the prisoners within Roe House, in terms of our engagement, in terms of this stocktake. They've welcomed us being involved in this particular stocktake. They felt that the stocktake provided the best opportunity to find a lasting solution towards a conflict-free environment. They've all told us, the staff, the POA, the Governors Association and senior staff, as an actual fact, the report that we have produced was a balanced report. We're saying that it's also a report that actually reflected all the concerns, particularly the concerns of the staff. And in that sort of context, in terms of what we're putting forward at this point in time, as I've already said, provides the best opportunity for a lasting solution, and one that is about ensuring the security of the prison is not diluted, that the staff and prisoner safety is not put at risk, that the staff are able to carry out their duties free from harm, intimidation or threat, and ensures the embedding of a prison system that is safe, humane and free from the experience of the past. That's our position, and that's what we put on our report.
Could I ask you finally, and I'll bring in other members, what's your view, the stocktake reports there, recommendations around it, what is your view in the prison service moving ahead of implementing some of these recommendations in the face of the ongoing threat not having been dealt with, and the abuse not having been dealt with, the targeting of staff not having been dealt with, and the prison service have decided as an act of commitment on their part that they will already make changes? What's the assessor's view on that?
Well, I suppose it comes from our experience of the 2010, and there's nobody who regrets, by the way, the murder of David Black, Chair, more than we do. And I don't think, with all due respects, that you have a monopoly on that condemnation, because I said to you,
I don't have a monopoly on it, Peter. But I sat in the living room of Mrs. Black. I was at the funeral of David Black. I knew David Black's family personally. My family worked with David Black. So I don't for 1 minute pretend to have a monopoly on this particular issue. But I have a very sound foundation to have a very clear understanding and view of how terrorists conduct themselves in respect of treating prison officers and their families.
Well, Chair, just let me, again, I want to go back to the issue. these people beside me, we were highly, highly aggrieved. In fact, it was a sort of traitorous, want of a better term, treatment for us, because we had put so much time and effort into ensuring that there was none of that behaviour, that murder going on. And when we went into the prison, we looked them in the eye and told them that they had reneged on the agreement because they had murdered David Black. Now, having said that, let me just carry on a little bit, because you're quite right. There's one difference, Chair, and there's a bit of a leap, because equally I have to say that NIPS did not introduce aspects of the agreement. So there was a situation between 2010 to 2012. There was a hiatus following the murder of David Black. That set it back another 2 years. And that's understandable, by the way, because then we had to have a lot of time, again, to start convincing prison authorities and the prison officers, because my concern, and at least we have one common objective, is the safety of workers in the prison service. That's my concern. And I hope, and I'm sure we agree on that one. But not to proceed to attempt to get a resolution of the outstanding difficulties or the implementation of aspects of the 2010 agreement, or now this one, would be detrimental, I maintain, to the welfare of prison officers, the welfare of Northern Ireland society. You're quite right about who moves first, but you will also note, by the way, there is a fundamental change in this particular document, the stocktake, from the 2010 agreement, because it specifically spells out internal and external threats. Okay? Now, you could say the prisoners, well, prisoners could often say, well, we're not threatening anybody. It's people outside. We're saying, no difference. For the first time in a document, we're saying that you need to give up not just your threats internally, personally to prison officers, but your friends outside, your supporters outside, have to also give up their threats on Facebook and social media to prison officers as well. And that I think is a significant difference. Now, let's take the other point you made, and it's really for NIPS to answer that. I think in the context of moving forward, because there's always, in any negotiation, who takes the first step or who blinks first. I think, or it's our opinion, one would assume, that if NIPS take the first step forward about a gesture of goodwill, it forces the prisoners and their colleagues. Sorry, Evan. Will you speak to me?
Yeah.
Well, could you let me finish, please, before you interrupt me, please? And I won't interrupt you, please, Edmund. Chair, what I was suggesting to you is, and I have to go back now on that.
Very sensitive.
Sorry?
You're very sensitive.
Well, Edmund, I'm here on a voluntary basis.
Yeah, well.
Okay, with all due respect, I've put 4 hard years of labour, of my own time and my own effort into this. And before you came in, it's not been nice, and it's been unsavoury. But I did it for what I believe is the good of Northern Ireland. Please, just bear with me. Sorry, Chair, come back a little bit there too. I think a gesture of goodwill by NIPS in implementing an aspect of this would suggest to me, if you're thinking properly, and if those of us who have been used to negotiation, puts the prisoners and their organisations on the back foot. Because it then says, we're prepared to attempt to live with this agreement, but your side of the coin and your side of the bargain has to be the lifting of the threats, which you've spoken about, which are still there currently, both internally and externally. And let's see how that will roll out. And then I think you should call me back and give me a good slap if it doesn't happen. And I'll stand up and honestly say, I'm walking away from this because I've put 4 years into it and it hasn't worked. And it may not work, by the way, Chair, but at least we give it our best shot.
Okay. Mr McGuinness.
Thank you very much, Chair, and I think it's been a very, very useful engagement despite the apparent tension and conflict in views, but I think it's very, very helpful. Could I say also, just from the outset, I attended the demonstration organised by the trade unions in the aftermath of prison officer David Black's murder. And I think there's no doubt that there was great strength of feeling coming from fellow workers at that demonstration, and it wasn't just simply a demonstration in Belfast, demonstrations elsewhere. And I share the condemnation and revulsion at that. Very important. I talked to Pat Ramsey, MLA, shortly before I came to this meeting. He has been tasked by the SDLP to liaise with prisoners and has carried out valuable work with prisoners in Row House. And he did make the point to me that it is vitally important that a commitment be given and action taken to prevent abuse, to prevent threats, both internal and external, to prison officers working within the prison regime. And that is very, very important. I endorse the sentiments of what the Chair has said in relation to that, and I think we all start from that point of view. And we do demand progress from that. This is a two-way process. It's not a one-way process, not concessions to prisoners. It is a two-way process, and I want to emphasise that point. That's just by way of comment. The stocktake, we've said, page 5, has created an opportunity to get things back on track, and I hope that that actually happens. I've mentioned the threats to prison officers and so forth, but you do specifically talk about communication is fundamental to success, and that on occasions the absence of a clear and concise communication process led to misinterpretation of the agreement. And then you go on to say the Prisoners' Forum should be the vehicle for processing issues of concern and to maintain effective channels of communication. I want to know a little bit more about that, how effective that could be, what are the problems in relation to that. And then finally, just one specific issue which I want to raise is revised family visiting arrangements, which the prisoners believe will be restrictive. If there could be some comment upon that. Thank you.
Chair,
and just incidentally, I just want to commend you collectively and individually for the work that you've done. I think it's invaluable work, and it's been very helpful, I believe, within the context of the whole political process.
Chairman, thank you, Mr. McGuinness. That's kind. Regarding the forum, the Prisoners' Forum was a vehicle that we believed from the beginning had the ability to resolve most of these problems on a dialogue basis. It was going to meet frequently. It was going to listen to what the prisoners said, listen to what the authorities said, a two-way exchange of information, and act or not act accordingly. But a key to it was that if the answer, as far as we were concerned, if the answer was going to be yes, say yes. If the answer is going to be no, say no. I think as human beings we all like to get a yes or a no. There was frustration because things appeared to be disappearing, queries on both sides, but particularly from the prisoners, just disappearing and never being followed up. So we've been focusing on the forum for a variety of reasons which the prison authorities can talk of better than we can. It hasn't been working. And our recommendation is for an independent chair to come in, not to give some sort of dreadful independence, I say dreadful, but independence as a driver, but someone who can understand, who can be, if you like, an honest broker to make sure that things are done properly, and when questions are asked, they are answered. And that's where it stands at the moment, and the Prison Service can explain and tell you where they're taking it. But it's to make it not over-bureaucratic, but a system that works, and we would like to think that everything that is concerned to the prisoners, that is fed to us, that's fed to staff on the wings, that's fed to governors by the prisoners and vice versa, could be regularised. And someone who knows how to run a committee, if you like, could deal with that. So that's what the recommendation is. The family visiting is outside our remit. as indeed is the question of separation entirely, which is for the NIO. We did comment on it in our report. We stuck our necks out because we felt that it would be a slightly hollow report if we didn't comment on all the issues. But we have no remit. Our terms of reference don't empower us to do that. The visiting, again, the details can be given by the prison authorities, but there was an issue over changes which to the visiting system, which the separated prisoners didn't like. They felt that they were going to make things worse rather than better, although there were a lot of things that we could see that would make them better. That creche was being opened up, toys. It looked pretty good, but the prisoners were having it day to day, and they felt. But they told us they'd rather stick with what they'd got than move to the new process. Now I understand that's where they're at the moment. They are staying. They're staying. The visits stay where they are, but there are still plans to improve. But those improvements depend on behaviour. They depend on a great number of things. So we comment on something outside our remit, but the immediate issue, the instant issue of irritation with the new system has been put perhaps only on hold.
Thank you very much, Chair.
Mr. McCartney.
Thank you very much, Chair, and again, thank you very much for both your presentation and your obvious commitment and patience and all of it took to put this together. When Leslie was speaking, she talked about a prison system that's, you said, safe, humane, and effective, and we would share that. We would say that all within the prison system should be treated with dignity and respect, and I think that flows on. It should be in a place where there is no conflict, where people can live out their lives, both in terms of being in prison and those that work there and those that service the prison do it in a conflict-free zone. I think as far back as 2010, when the trade union did take the initiative along with Cregan Enterprise Limited, we would have been supportive of it, and we're on the public record as saying that. And I think the agreement reached at that particular time, in our opinion, was an appropriate way to address the situation in Maghaberry. I think the appointment of the assessors was appropriate as well at that time. And there's absolutely no doubt, and I think we all can accept this, that in the intervening 4 years an opportunity has been missed. And I suppose we could spend a long time trying to say how or when. And in the middle of this, we have to remember that David Black was murdered, and one can see very easily why prison staff felt the way they did about that particular thing. But I don't think we should spend too much time now, at this minute in time, apportioning blame. But I think the stocktake, which came from an initiative from the Prisoner Ombudsman, I think it was appropriate. And I think the way that has been presented here today, then certainly we welcome the outcome of it. I think in many ways, I think Peter said this when he was speaking, it has now distilled it down. The August 2010 principles are there. They're there to be seen. I think the stocktake does present challenges, and it presents challenges for both the prison service and the prisoners. And I think Peter outlined his rationale for that, and I think it's an appropriate rationale, because whatever in the future, then I think, and when Chris McCabe was speaking, he made this point about people wanting clarity around yes or no, then I think now the challenges are clear, and those in breach of them will be seen more speedily, more readily, and I think we can call it better. I think the last time maybe perhaps we hoped that these things would be resolved, but in waiting and hoping, I think maybe we all lost the opportunity. I just want to speak about the process as it goes forward. Do you feel that you have a role in assessing how it progresses, or do you see that now being part of the remit of the independent chair?
My answer to that is I'm finished. I can't do any more. I've done what I've done. I think we have set in train a fair compromise agreement, for want of a better term, and if it is actually operated, would give all people and all parties to the agreement, and again, from my angle, the prison staff, a safe, secure environment. It will give the people of Northern Ireland confidence that their prison, when people are sentenced to prison, as dissident Republicans or loyalists for that matter, that they have a system which they can live with. We don't need any more protests, dirty or otherwise, We don't need any more outside protests. We don't need any more oxygen going to certain people, and that it will give a situation where it will be a conflict zone, free zone, for both those who operate and work professionally in the system and for those who are imprisoned in it. I'm sure some of my colleagues may well wish to become and remain involved. But personally, for me, I have come to the end of the line in that. I don't see me, certainly, and obviously retiring next year one way or another anyway, I don't see me coming forward and engaging in the process. However, I would assume that if some person did tap me on the shoulder in the future, I probably would become involved purely for one reason. And one reason is this, because I do share the view of the Chair, and that is that the deal is there and there's no more asks. That's the parameters of the deal, Chair. No more asks. No more, as you would term it, and I'm quoting your good self, Chair, rewards. That's the deal. Ain't no more asks within that deal. The deal is there. It took probably 4 years, and that's the end of the line, as far as I would be concerned personally. And if everyone who signed up to this adhered to it, there ain't no more to give from the prison service, and no more asks should be demanded by the prisoners. That's the deal.
Okay, and just in terms, I know this from our own visits to Macabry and indeed talking to both prison governors and obviously prisoners, the issue of people held outside the separated regime, and I know there's a recommendation. Do you intend servicing this with the NIO, or do you see that as a responsibility of the department in terms of eligibility and your recommendation of an independent assessment of the reasons why people are not permitted?
Well, as a result of that clause within the agreement, and as a result of the stock take being published, we have been requested to send a copy to the Secretary of State and to the Northern Ireland Office. And the Northern Ireland Office has been in contact with us. They're looking at that particular aspect of the agreement, and in terms of the situation around the isolation of prisoners held within the CSU, that was outside the original terms of the original agreement, but it was raised. But we felt it was important that we would obviously flag it up, because we do believe that the current procedure of prolonged separation or isolation of any prisoner, particular prisoner, for a period of over 3.5 years is something that needs to be raised from a humanitarian point of view. But the Northern Ireland Office and the Secretary of State have indicated that they will respond to that aspect of the document.
Okay, I mean, all our recommendations are fairly straightforward, so I'm just taking them as read as the appropriate way to address this. But there is a reference to, and this became part of the August 2010 template, and also day man hours, and that's around the full body strip searching. You use a term multi-mode threat detector. I make the assumption that you have seen this in operation somewhere. Would you like to elaborate on that?
Well, again, is that the issue of searching has been one of those areas of contention, particularly in terms of exiting and entering the prison. And indeed, our recommendation is that the Northern Ireland Prison Service should move more towards intelligence-led searching of prisoners whilst in prison. But in terms of the recommendation, yes, we have obviously looked at that particular piece of equipment. It's currently in the prison system within this island, in actual fact in Portlaoise Prison. And in that sort of situation, all we're doing is, again, we're reflecting on, for example, the latest report that was actually also given out by the Criminal Justice Inspector for Northern Ireland in October 2014, where in that report they also said that this issue of full body searching should be looked at slightly different. And we're also drawing on the previous report by Dame Anne Ords in her final report of October 2011 in terms of the review of the Northern Ireland Prison Service, that the system should move away from the current process of full body searching that is intrusive and invades the privacy of all prisoners. So therefore we see this recommendation in line with all of that, and we do know that that is something which the Northern Ireland Prison Service says that they would explore to see whether that would meet the criteria that they need. It would be something that would be in addition to the use of the boss chair.
Okay, thank you. And just a final point here, and it's just a broad comment. I mean, I do believe that this offers us a way forward, and I suppose with Peter maybe saying that he's come to the end of the road, I'm not sure about the hours thing. I'm not even asked you the other day to put yourself in the spot, but certainly I think from our party's perspective that we would sort of welcome and commend you for your efforts over the last number of years. I think you've done a good service to trying to ensure that our prisons can be conflict-free. So thank you very much.
Okay. Mr. Free.
Yeah, thank you, Chair. Can I ask, with regards to the stock take report, and I'm only on the committee for a brief period of time, so I haven't been studying of great depth the work that you've done up to this point, and I'm not questioning your sincerity in any shape or form. Let me just make that very clear. But the actual stock take report itself says to me, whilst it could be a massive body of work, it's really a snapshot of a situation here now. So I want you to describe for me the longevity of this report, and indeed whatever deal is done. And whilst there was a negotiation had and completed, it seems to me that the prison service would continue to do A, B and C, whether that be continue to review the issue of full body searching, or look and monitor the family visits, education provision, all about reviewing. Can you explain to me the longevity of the deal and how you can be so sure that this deal will stick?
Well, it's a very. I don't have a crystal ball, Paul. Okay, but I do believe one thing, that will the review stick or not? That's up to both parties. Okay. I think there's a degree of sincerity not there now, which may not have been there before, to resolve this particular issue once and for all, and to create this conflict-free society or prison society. When you talk about, yeah, I mean, how long? I don't really know. I can't answer that question. All I do know is that, from my background, my experience, when you make an agreement, you stick to it. On such stage or other, either or parties wish to change it at a future date, and then that will take the form, one assumes, of some form of negotiation. With regard to the term review, I understand the context and why you asked the question. I would put it to you, and again, it's my opinion on that there are always evolving technological advances, and I think we need to review a situation within the context again of the principles of the security of the prison and the security and welfare of the staff. So, we all know, we all go through airports now. You'll see all sorts of different means of protecting people from the airplane safety, from bringing things onto prisons. I recently, with one of your colleagues, I was in Cuba with one of your colleagues recently, and we see them, which they have also in Portlaoise prison, by the way. They've also this thing in Cuba as well, which is a sort of a scan with a piece of cotton, which can tell you whether A, you've been in contact with drugs recently in the last 14 days, or indeed various other elements which one could probably describe as constituents of explosives. Okay. So what I'm just suggesting to you, these are the reviews we're talking about. The other thing is you could have a full body scan, which you'll see in some airports as well. And as I understand it, the difficulty with that may well be is there could be a health hazard for that for the prisoners, and there may well actually be a health hazard for that for the staff who are operating it. The jury's out of that at the moment. I don't know what the difficulties of that are. But what I'm suggesting to you is it's maybe well a more humane way of rather than scrutinising somebody's bodily orifices. And in that context, by the way, when I visited Portlaoise Jail, I was informed by the then governor, a chap called Governor Connolly, that they could scrutinise a bodily orifice all day long, but they still couldn't see anything which would be inside that particular orifice. So what I'm suggesting to you is there may well be technological advances which give greater security to the prison service and the prison officers. So that's where that review point comes in.
And I accept that. But advances in technology will happen anyway. Why did you see fit to have it in your stock take report? Because and I'll preface that, because it looks to me that you're giving an excuse to the prisoners to, at some point down the line, change or review their stance on the stock take review or this agreement.
But can I say I think it's really important to understand what the terms of reference for the stock take were. So that in terms of that, we had to look at all the issues that were set down in the 2010 agreement, and searching was one of those issues that was set down. I think it's also maybe important to say that the stock take wasn't a negotiation, it was a stock take. And in the process of that, we saw that there were other issues that were there that needed to be looked at, and that's why there are other issues recommended there for review as well. So the parameters for all of this are set down in the Row House Agreement.
Yes.
And the bottom line is, and the bottom line that we have emphasised in the stocktake is that unless the fundamental principles of the Row House Agreement are adhered to, then there's nowhere to go here. That is the bottom line, and that is the negotiation.
And maybe in addition to that, we haven't set out to appease anyone in this particular stocktake. As Leslie says, it is a stocktake of what was there. And in terms of the recommendations that we have put forward, we have actually made it abundantly clear, they're all predicated on the fact is that all threats, both internally and externally, disappear. Now, in that situation, there was also a situation which was being flagged up to us by the Northern Ireland Prison Service and by the prisoners, and maybe even beyond the prisoners, the families and the communities which they come from, that there was an impasse, and the impasse wasn't going anywhere, and the impasse had to be broken for the greater good of the prison service and the staff who work on it, and also in terms of the overall well-being of prisoners and how that impacts on the wider community. So in that context, the reason we think that the stocktake and the recommendations at this stage provides a very unique opportunity, which we believe, maybe naively, but we believe it, is in actual fact, this is the end game. And in that sort of context, the point that Peter's made is that both the prisoners, in actual fact, it's in the paper today, right? The prisoners have themselves saying that this is the way forward. So therefore, it's not a question of, they've now welcomed the stocktake. They also want the situation resolved, and we think that's the best way forward.
But I'm sure they would welcome this. And you do use the word appeasement.
I was referring to what was flagged up to us.
Yeah, and I never used those terms, but to be honest with you, that is probably the only way to describe it. Now, having said that, I know that you have all had a horrendous job of work to do. And to be honest with you, if I was here when you started this process, I would have surmised that at the end of the process it wouldn't work. Now, when you do any negotiating, whether it be in business, and you'll all be experienced, both parties have to bring something to the table. And it seems to me that the only thing that prisoners brought to the table was that threats would disappear and they would act in proper conduct that we expect society to deal and react in anyway. So it can't be balanced. How can it be balanced when all one party has to do is stop doing what they're doing? There is no pain there in a negotiation or a balanced deal. There's give and take, but there's been no give on the side of the prisoners. How could they? What have they got to give?
Well, just let me answer that, Paul, if I can. Okay. And again, you come from a different view from it than probably we do. But again, I understand why you come from that particular view. But just let's say when we go into Roe House, we turn right. Okay. On the left-hand side, there are 2 stories. Okay. Where, for example, there are prisoners out on the landing all the time. Okay. Unlike Roe House, where there are only 3 allowed up in one landing and 3 allowed out in the other landing. Okay. The people on the left, who are ordinary prisoners, for want of a term, okay, the separated prisoners over here, they have to go through turnstiles after turnstile after what? These guys here have no turnstiles. And yet the interesting thing, the guys over here, what we term the ordinary prisoners, have assaulted more prison officers than your separated prisoners. So what I'm suggesting to you is, and there are reasons that you could equally come back and say, well, they're supposed to be more disciplined in some form of military, whatever, right? The end game for all of us is to create an environment where, first of all, the people do their time. Right? They do their time in a safe and secure prison. They do it in such a sense that they don't go around like the guys over on the other side, beating up, threatening, hitting, punching, spitting, and coming back to the situation which the chair explained quite, and we were there, by the way, as well, and he's quite right, in a urinated, urine-saturated environment. So there has to be somewhere along the line, because there has to be an alternative. And if the other alternative isn't working, even in those negotiations we're talking about outside or whatever, we switch strategies to ensure that somewhere along the line we will get an environment where both parties can live in and within, without diluting the substantive issues, which are security in the prison, no escapes, none of that carry on, and the safety of the prison officers. Now, I can understand your frustration to say, who's giving, right? I think we're all giving. But the end game is that we don't have the prison wreck anymore, which costs us money. We don't have threats to the prison officers anymore, externally or internally anymore. We don't have the people attempting to escape from the prison anymore. Okay? So that should give us a degree of security.
What if that changes tomorrow?
Well, if it leaves tomorrow, then it's like anything. If you breach the agreement's off the table.
And what happens then?
Well, what happens? I don't know, Paul. All I do is maybe somebody else will volunteer to go in there, because I've had I'm done with it. and you may find that facetious.
No,
but after 4 years, seriously, as far as I'm concerned, and I've told the prisoners this as well, I've had enough of it. Okay? Because it's difficult, as you say, but at least I can say and hold my head up and say, I looked him in the eye and I told him, you broke the agreement, you murdered David Black, to their face, sitting from there to me, right? Told them to their face. I didn't issue statements, which I did, by the way, but at least, and by the way, like other people, like the prisoners, I've received death threats as well for condemning dissident Republicans. So, you know, it's wonderful sitting here, or whoever, being critical, and that's grand. I know you're not being critical for the sake of being critical, and you're trying to get to a rationale behind it. But I believe that we have done some sort of a service for the people of Northern Ireland. I can't answer what the future holds. And by the way, it wouldn't surprise me if some stage in the future somebody breaks the agreement. We don't know. But all I can say to you is, everybody within the parameters of that, that's the end of the agreement. The parameters are there. It's up to both sides to work it. Nobody else.
Can I just clarify something? I'm asking questions, and I may be critical, but I'm asking questions because that is the questions that the public would expect me to ask, because I am.
No problem. No problem.
I am the public.
Yes. But all I'm suggesting to you is, what is the... Well, nobody can answer the question. If we didn't have this, what's the alternative?
Could I add a little bit to that, maybe, if it's okay? I suppose I totally get the view if all we're doing is expecting people to behave like human beings, then what's the big deal? We should have expected that in the first place. But from my point of view, I work in North Belfast. I've worked there for 25 years. So I've stood in the House with the prison officer and with the RUC officer who have been chucking their stuff into black bags. They're not there anyway. Their family are there. They've already gone. And we're getting them out as quickly as we can. Now, that shouldn't be continuing to happen in this day and age, and in terms of the society in which we're living in and the agreements that have been reached and the hopes that we have. So anything that I can do to stop that happening into the future, I will do. And like Peter, there are no guarantees, but all we can do is do our very best so that that doesn't have to happen to people again.
Okay, thank you, Chair.
Mr. Chair, could I just say something too? Because you mentioned you mentioned timing and when will this happen. We in bold in our report actually we say we believe there should be a timeline of 6 months for this, and that's important to us to resolve any outstanding issues. Okay, idealistic, we would like them all to be resolved, but our expectation is at the end of 6 months we will know where we are. The electronic searching is a problem. It's out. To find a safe system seems to be the holy grail that may never be found, and we have reinforced and emphasised that to the prisoners over and over. But there is a desire on both sides, on all sides, to keep on looking. But that is the biggest and the only promise can be given about this. Although we're a totally united group, and my friend Peter and I talk about everything, and I've heard Peter's opinion. My own about his immediate retirement, leaving the field with honour. The 6 month period to me seems a more. I personally would feel an ownership of this until the 6 months have worked their way out, because we've made recommendations, particularly about a chair and a reorganising, invigorated prisoners forum, and I think we have a relationship, and I won't say for good or for bad. We have a good relationship. With the Minister, with his senior management in the prison service, with the people in the prison who are infinitely and tirelessly courteous to us when we're visiting, which impresses me very much. And as far as it goes, with the prisoners as well. And I think a phasing out would be better rather than an abrupt end of our role, just to see that through. I would feel we've committed so much to it, I would like to continue for a little while longer down that way. That's my own view.
Okay, Chair. Thank you.
Good. Thank you, Herman. I have no doubt that all of the members here today are well-meaning in what they're attempting to do, and that their desire is an appropriate desire, and that is for a peaceful retirement in the prison. However, having the right motivation doesn't necessarily deliver the right outcomes and the right policies, and I don't believe that they're doing that. In my history of life, and I have now got grey hairs to demonstrate that I've been around for a reasonable period of time, I have never witnessed rewarding bad behaviour with an outcome other than more bad behaviour. So I think that concept of actually rewarding those who behave badly is a flawed concept, and one where you have got wrong in the initiation of your process. These prisoners are not in prison because they have shoplifted to the value of 60 or 70 quid. These are amongst the most dangerous people in Northern Ireland. Therefore, going down a route which makes that particular wing in Maghaberry more and more like an open prison is one which is highly dangerous for the prison staff. We received phone calls from representatives of the Prison Officers Association last week who have expressed concern that there are lethal weapons within that particular facility. So we want to relax the means of actually identifying and searches. That strikes me as being very, very dangerous. And, you know, I don't get the feedback from prison officers, and I represent a constituency which is more prison officers than any other constituency in Northern Ireland. We're not getting the feedback that they're happy with your recommendations. Far from it.
Can I respond to that? Clearly, when we set out in this particular process, we set out in the process which was inclusive, in which we talked to staff when we go into the prison. We asked to meet the representatives in terms of the POA. We also asked to meet the Governors Association within the prison. Each of those organisations were happy and didn't object at all to the process that we were undertaking. Indeed, when we were in the prison last week, they told us that they felt that the report was an extremely balanced report, that for the first time in quite a number of years, of all the reports that's been written over the years about prison conditions in Northern Ireland, it was the first report that actually reflected their view. They've also been telling us that they want this impasse broken. And in that context, they felt that the stocktake and what we're proposing obviously is a route map out of that. Now, clearly, you know, at the end of the day, it is our view of someone who is, we feel like that we're actually in prison ourselves, is that the fact is that we have looked at this, we've researched it, we have analysed it, given the information that has been given to us by the Northern Ireland Prison Service and others, is that we're actually simply saying is that we're not at all relaxing the procedure of searching. We would actually argue that we're actually proposing is enhancing it and making it actually safer for everyone. So we would actually argue that what we've proposed in terms of searching is not diluting the safety of the prison, but I've said enhancing it. And in that sort of context, you know, we stand or fall on the particular recommendations that we put forward. But I would suggest that we should not throw away this opportunity to actually resolve the current situation within Roe House.
Yeah, I know. There's no one else, but sorry, Mr. Elliott's wanting in. I'll bring him in a moment. You're familiar with the conditions document that the Republicans submitted.
That's the one they give us.
One of the demands that they've made was around the policy of controlled movement ending and daytime and nighttime lockups ending. Obviously, your stocktake has recommended allowing up to 6 out under controlled movement, and the view is that your recommendation is a step towards what they would want to achieve. But are you satisfied that your stocktake, in the light of all of the demands that were issued in that conditions document, will be the end of the matter in respect of the Republicans' pursuit of what they envisage in their conditions document?
All I'll repeat to you, Chair, and it's a good question, is that's the agreement there. What's written down there is the agreement. One would assume, no, I don't know, to the end in the lockup, I mean, I just couldn't envisage that, right? I mean, that wouldn't be something I don't think anybody would envisage somehow that lock up at night time or lock out in the morning. But I just want to emphasise that our agreement is here. What we've put before you is the agreement. There obviously is a view, whether it be 6 on the landing at any stage or whatever, right? Even if you multiplied it, what the prisoners have always been saying to us is you can have as many prison officers in that particular wing, and they would like to move around the place. But then we're back to my answer to Paul earlier, and that is if they breach the agreement and threaten the agreement or overpower the agreement, whatever gains they may have in this puts them all back to square one. So the onus from your question would be, if I was one of the prisoners, if I have something which makes my life easier and I want to build up an atmosphere in the prison which at least gets me through some form of and I put this in inverted commas, quality of life in the prison, why would I damage something which Elbin and Paul think is a terrible thing, or view that it's rewarding bad behaviour? Why would they damage it? And I've stated from my particular point of view is that we have had the parameters are enshrined in here, the principles are enshrined in this agreement, incorporate stringently the agreed principles, which they don't need to repeat, and therefore I believe that while the prisoners may have wonderful ideas, they might want sun deck or whatever else they might need.
Swings and slides as well as sun decks, I think.
All I'm suggesting to you is the deal is here, the parameters are there, set out in 2010 and set out here, that there would eventually could be, and you have to build up the trust scenario as well, that there is some degree of more movement in the prison. But it all again comes back to the non-breaching of what we termed an agreement, which has to be adhered to by both parties.
And just in addition to that, I think it is important that everything is obviously predicated on what was in the August 2010 agreement. All with respect of what's in that document, which the prisoners informed us that they didn't leak. They don't know where it came from. And that context is that the agreement is quite clear, right? It is never talking about the fact that you throw one up and they can move all around the place. The agreement is quite specific. It talks about supervised free flow. Supervised free flow, which means that the fact is that that's just something which would be controlled by the Northern Ireland Prison Service and the staff that works in it.
And it's not come back to a maze situation.
Because the logic of behaving badly and then being recompensed for behaving badly is one that will actually entice people to do the same and repeat the same actions over and over again. So they bag the concession, they then behave badly again, then they bag further concessions. And unfortunately, the individuals before us has fallen into that particular trap.
But I think it's also important to say that a political decision was made here by politicians that because of the unique situation that exists in this part of the world, that there was a necessity for separated conditions. And that separated document...
let me correct that, Donald. Direct rule.
Direct rule politicians, and that was endorsed here. So the fact is that there is...
It certainly was not endorsed.
With the greatest respect, the fact is that there is now a separated regime for both Republic and Loyalists. Now, the fact is that you and I, right, and we're also a member of the public, is that the fact is we have to deal with that reality. And what we're attempting to do at the moment is to deal with the realities in Northern Ireland. And unfortunately, this particular issue, like lots of other issues, clearly gets the past comes up to haunt us, and people are simply saying we can't go back to the maze. I can assure you from my experience of going into McGarry prison, this is a prison within a prison, and this is not a maze scenario.
The other thing I suppose I would say for myself, going through the 4 years of this and not knowing Republican wings and New Loyalist wings before this, but didn't know Republican wings, As far as I am concerned, the parameters are here. They can be pushed against, they can be challenged, people can dislike them, but the parameters are here. And nothing can be done, and in our view, nothing should be done that compromises safety for anybody in Roe House, and that means staff as well as prisoners. So if these parameters, if people think they can move them, well, maybe they can try, but it ain't going nowhere.
Let me bring in Mr Elliott, who hasn't had a chance in this session.
Chair, thank you, and again apologies, I had to go out to another meeting there. Thanks for that. Just some issues of clarification first. In the briefing documents that we have and the report, it talks about the agreed principles, and then it talks about undertakings of the agreement. Now, I can see the agreed principles, but I can't see the undertakings. I'm assuming there were a series of undertakings.
There was a considerable number of undertakings in terms of what changes would take place. And I think what's missed here at the moment is what the Northern Ireland Prison Service, in terms of what the undertakings which they gave within the August Agreement, they've actually implemented quite a number of those changes, and in actual fact, a considerable number of those. And then there was if you like, breakdown was in and around maybe two core issues, which was around the issue of what the prisoners would call controlled movement, and then the other issue about exiting and entering the prison.
So in 2010 there was a list of undertakings?
Yes.
Okay. And that's what you had to work towards? Okay.
And we referred to that, and lots of those have been...
Yeah, I see all the issues that have been implemented and not implemented, but again, it doesn't give me a list of the undertakings. Were the Prison Officers Association and the prison officers themselves party to that agreement?
Well, not at the time. We would have assumed, because we were dealing with the...
Assumed? Peter, normally you're much more specific than that. You don't assume very much.
But I'm trying to suggest to you that we were dealing with the governors, a number of governors. The original 2010 agreement was signed off by the governor and each prisoner. They all signed it at the time. There were 28 of prisoners, and the governor signed off on their behalf. Now, we weren't dealing directly with the POA, but one would assume that there would have been communications on a regular basis. Now, I think that's one of the recommendations we have, and there was no communication, and I think that's one of the reasons. And again, it's very hard to start, apportioning culpability, which I referred to earlier, because I think that lack of communication between the governors who we were dealing with and who signed off on the agreement and the prison officers, I think that contributed to huge unrest among the prison staff, because they were not apparently consulted somewhere along the line, and that communication, I think, broke down. Then the forum didn't really take off as it should have, and I think that would have been, for us, the mechanism or the vehicle for sorting out a lot of the problems and allowing the agreement to be implemented on the basis of which it should have been, and the ethos and the culture of what it should be within a better environment. So if you want a copy of it, I'm not so sure. I don't have a copy handy, but I'm sure we can give you a copy of the August 10th agreement.
Okay, appreciate that. But just to be clear, those that were, did you get the feeling that those who had to implement this on the ground, in other words, the prison officers, were not party to that agreement in 2010?
I honestly don't know, to be fair to you. What I would suggest...
I find that rather strange, Peter. I have to say, if you've went through a stock take and you have went through a review, that you haven't been able to make a judgment as to whether the prison officers were actually...
Well, my colleague spoke to the prison officers and that's what happened.
And in terms of the stock take? In terms of the stock take?
No, in terms of the agreement, when you were carrying out the stock take, was there clear evidence or information that the prison officers who had to implement this were party to that agreement in 2010 or not?
Our direct negotiations at that particular time was with senior governors and also with the Director General of the Prison Service.
And not the prison officers? So prison officers that had to implement this were broadly ignored in this process. That's what you're saying?
But we're not saying that because, I mean, they would have seen us in there every day. They would have said, what are you fluting around in here for? I mean, you know, what are you doing in here every day?
Did you have no discussion with them about their role?
Well, we had a discussion with them on
or your role or their role, or, you know, I find it very strange that the people who are at the cold face of this, the actual prison officers, seem to be generally ignored in this process.
But would you not accept that, you know, there is a responsibility on the governors at the particular time and the Director General, who obviously invited us in and allowed us to obviously facilitate this particular process on their behalf, that they have a responsibility to their staff, ensure that staff were kept up to speed in this. You know, clearly from our point of view, at that particular time, when we were negotiating that particular agreement, and given the tension that was out in the particular communities and the spillover of that, we were particularly given a task, right, to facilitate agreement between the Northern Ireland Prison Service and those prisoners at that particular time. Now, that was our remit at that time. Now, there's others who have a responsibility to obviously ensure that the system itself opens up those channels within their own system to keep us informed. You can't actually throw that responsibility back on us at that particular time.
Could I?
No, I think would it be fair to say, just because you're in the building, flitting about it, to expect staff to relay their views about an agreement that you're putting together? You know, when I'm in and out of McGabry, 90% of the time the staff will be polite and do a professional job. On the odd occasion I'll get berated as to why the exit scheme didn't include 45-year-olds rather than 50. But I think you would find it isn't quite fair to say just because you were in the building that was an extent of process for prison officers.
For the record, since the agreement was signed and Leslie Carroll and I joined the team and it became the assessment team, one of the very first meetings I remember having, along with Conal McFeely, was at Malile, meeting the POA. We made it, as soon as the agreement was there, and that's all I can speak for, we made it our business, and we have repeated those meetings as most recently as you've heard with the Governors Association and others as part of this review. So they became central to us, one of the key players, and we identified key players, a wide range of key players, and the representatives of the staff were always there, and we've kept in touch since. So we're talking about history, and I don't know what happened then, but I know what's happened since. So today it's absolutely recognised as a duty of ours.
So is it fair to say what you're indicating to me is that you seem to be, Conal, putting some of the blame back on the senior authority of the prison staff or the prison management as to not communicating with the prison officers, that you didn't feel it was your responsibility in your grouping to actually do that, but that since then there has been progress at doing that through your channels? From the period the agreement was signed off and the assessment team was put in place, and we were then told that we would come in and assess the particular agreement, the first thing that we did as assessors, right, Chris and myself, was we made it our business to go to people concerned to say, look, this is what's happening, and it's important that your members know exactly what we're doing. And we've been doing that for the last 4 years. I think it would be unfair to say that the staff within Roe House were also fully aware, because the document was circulated to staff. My understanding, within 24 hours of the document being signed off on by the Governor. Yeah, but they were no part of the agreement.
But again,
they were given a fait accompli. Is that right?
Well, again, I don't know if it's a fait accompli. At that stage, you know, Peter and myself...
Yeah, but if they were given the document after it was agreed. They were given the agreement when it was agreed. They were aware
that the fact that we were negotiating that agreement, and they had, at times, very robust conversations with myself and Peter.
Yeah.
And from that point of view...
Would you say that you felt they were part of the agreement or not?
Well, again, they were aware that the agreement was obviously being negotiated.
They were aware of it, but they weren't part of it. Okay.
But the agreement was there, Tom, but it was never implemented anyway.
Well, they're members of the prison service. The agreement was with the prison service. I understand what you're saying. I understand what you're saying, that it wasn't negotiated face to face with the officers on the wing. Nevertheless, they're members of the prison service, and the agreement was signed by the Governor on behalf of the prison service.
Yeah. So, but I'm merely trying to establish what role those prison officers on the ground had in any way. Okay,
and the key point from that, if we bring it right up to date to where we are today in terms of the stocktake, we have made every effort to talk to staff, the POA, the Governors Association. Everybody was fully aware of what the stocktake was about. And all we can do, in all honesty, back to this particular committee, to say the feedback which we're getting from the NUPs is that they're broadly supportive of this as an attempt to break the impasse which is there at the moment. And we've also said to the prisoners, right, that look, we can't keep coming on here over a 4-year period. We're trying to find a way out of this impasse, and they've also said they want a way out of the impasse. And we're simply saying we feel that what we've laid down in the stocktake is the end game for everyone.
Sorry, one final question, Chairman, may not be relevant to them answering, but do you feel in your discussions with the prisoners that they get it that they're supposed to be in there for punishment?
I wouldn't, and quite honestly, answer that. I don't think that would be their view. Having said that, I mean, and to repeat again, put on the record, we had very, very robust difficulties with the prisoners. I'm a toothless tiger, he's something else, and he's something else, and he's a spook, and Leslie's something else. So, I mean, I just suggest to you that it hasn't, it's been quite rough when you go in there.
Thank you, Chair.
Okay. Just last one for clarity. Did the POA sign off on the recommendations in the stocktake? Did they officially endorse it, or is it just the prison service management who've endorsed it?
What we were asked to do was a stocktake by the Minister. It was therefore for us to give the stocktake report to the Minister. In terms of the consultations, we spoke to the POA, as we've said, but it wasn't for us to ask the POA to sign off.
Okay, can I thank you?
Okay, thanks very much, Chair. And hopefully you don't see me here again on this particular issue anyway. Thanks very much, Mike. Thank you.
Okay, members, let's go into the next session. We'll wait for prison service officials to come in. I must have set my brief down, Okay, members, there's relevant pages are pages 21 to 45 of your meeting folder in terms of the prison service's response to the stocktake report. And so we'll just wait for prison service officials to come in, if someone wants to let them in.
I think they know how to open closed doors.
Control supervision.
Okay, can I welcome Sue McAllister, Director General of the Prison Service, and Paul Cockwell, Director of Offender Policy and Operations of the Prison Service to the meeting. You're both very welcome, and as normal we'll record this by Hansard. Obviously, Director, we've got the written statement in respect of the Prison Service's response to stocktake, so I'll invite you if you want to make some brief remarks, and then members will have some questions. So,
thank you, Chair. We have no opening statement to make. We're just here at your request, so very happy to answer any questions that you have.
Okay, I appreciate that. That allows us to get straight into the substantive part of the meeting. The one aspect of this that I want some clarity on is why, given that the recommendations from stocktake and the evidence that we've heard again today has said all of these recommendations, irrespective of the rights and wrongs, and we'll probably get on to that, is predicated on the abuse, the threats, stopping against staff, both internal and external. And that continues to this day. Why then have you decided to make a relaxation in terms of allowing people onto the landings whenever they have failed to even meet that initial first test that your assessor said would predicate any of these changes from being implemented?
You're absolutely right that all of the progress that we can make in relation to responding to the stocktake is predicated on an environment in which our staff are not subject to threats or intimidation. But we have to give the stocktake recommendations some momentum, and somebody has to make the first move and take the first step. And as we know from our many years of working in prisons, the relationship between prisoners and staff and the people who run the prisons is not an equal relationship. It is a relationship in which we hold all of the power, and so it is absolutely appropriate that we make that first move, and that's what we have done. But we are absolutely clear that any further movement towards a more normalised environment, but not a normal environment, is predicated on the removal of those threats and that intimidation.
When I was in Row House a number of weeks ago, it was drawn to my attention that the grill is open, connecting the upper and lower landings, and staff made it clear to me that that was something that they were concerned about, and a decision had been taken to do that, and it hadn't been reversed. So not only have you made a preemptive move in terms of these recommendations in the face of ongoing threat, you'd already made a concession in terms of that particular grill, and I would be interested on a response as to how that grill was opened and what has been done to address the concerns of staff that I heard firsthand.
Okay, I'm going to ask Paul to respond, because the tactical management of the physical and procedural and dynamic security of Row 3 and 4 is something that he's closer to. But I would want to just give it some context and say that any decisions we make about proportionate security, whether that be physical, procedural or dynamic security, are not concessions, that we do nothing that we do not believe to be safe, and that we continue to control that environment. But Paul can, I think, shed some very helpful light on the issue of the grill, which did become an issue. I'm fully aware of that.
Until very recently, the regime on Row House was divided. Two regimes were in operation for separate groupings. And at the start of the stocktake process, the prisoners made it known that they wished to act as one group to maximise opportunities to use the regimes, and we welcomed that. In the immediate aftermath, our haste to respond to it, a tactical decision was taken to leave a grill unlocked. I can place on the record that that tactical decision was reversed, and that decision was taken at a local. The original decision was taken at a local level, and the decision to reverse it was taken at a local level. This was something that was short-lived.
Was it wrong to have made that response so quickly, and I think you said in haste?
No, I mean, I'd like to answer that. No, I actually think it was the right decision to take at that time, bearing in mind the information that was available at that time. But as with any decision, you should reflect upon its impact and assess what follows. And having assessed a local decision, quite rightly in this case, was to reverse the initial decision.
The recommendation about the independent chair for the Prisoners Forum, the response has been this needs more substantive consideration. Can I assume from that then you haven't automatically accepted that recommendation?
We have accepted that recommendation, but we have not yet identified who the independent chair should be.
Who currently chairs the Prisoner Forum?
It's currently chaired by the functional head or the unit manager, so a middle manager. We welcome the recommendation, and we think it is going to be helpful to us to have that independent chair, an arrangement which will be reviewed after 6 months. It will put some rigour into the process. It will be very helpful. I speak as somebody who has chaired many prisoner forums. I'm sure Paul has as well. It will be helpful to be able to have that independent input, if not permanently, at least for a temporary.
Very much so.
How normal is it in other prison establishments in GB, for example, to have a prisoners' forum?
Absolutely normal.
And how normal is it that that would be an independent chair of the Prisoners Forum in those other institutions?
I would, first of all, it's absolutely the norm to have prisoners' forums, and there are a number of ways in which those forums can be chaired independently. There are some outside organisations that provide chairs for those types of fora committees. There's an organisation called Use a Voice. There's an organisation which is supported by NACRO. There are a number of ways in which governors can choose to have that independent input. So it's certainly not unique to this particular forum.
And some of those organisations you've mentioned will even run elections to find out those that will sit in the Senate of that forum.
Yeah.
I think the fear that I would have on that is currently it's chaired by the Prison Service. So you've rightly said that the Prison Service has all the power, the way it should be, and I certainly agree with that and welcome that comment. But when it comes to then chairing a forum, and clearly there are those who feel Prison Service don't hold all the power and are demanding changes, that it then looks to me as though we've got an independent, neutral chair and you've got two opposing sides, and we're going to thresh out these issues and reach compromises and negotiations, and it doesn't strike me as the Prison Service has all the power.
Let's be clear. We are very clear that the deprivation of liberty is the punishment, and that prisoners are in prison as a punishment, and it is being deprived of their liberty that is the punishment. The safest thing for us as members of the prison service, and the safest thing for communities in terms of running well-ordered and decent prisons, is to have a decent environment for everybody, which does not preclude having a process by which prisoners can be involved in some of the decisions that affect their daily lives. So decisions about, for example, visiting arrangements, decisions about food, decisions about access to craft activities, to learning and skills, are all matters for which it is absolutely appropriate and desirable that prisoners have an input, have a voice. Prisoners, we serve no good by infantilising prisoners by making all those decisions for them. We certainly would not be proposing that any decisions about, for example, security or order in the prison would be ceded to those fora. So it is about having an appropriate mechanism for involving prisoners in decisions about their daily life. And those are the type of issues that we would envisage being discussed at that forum with that independent chair. Do you want to say?
Significantly, we don't envisage a situation where the chair operates with executive powers. They don't hold the casting vote. Their role is, however, to hold people to account. So if commitments are laid before the forum that says, at the next meeting, I can give you a response to what you were asking me, then it would be quite right and proper that that individual is held to account.
Yeah. In terms of the stock take, the state of compliance section, and it said that principles of the agreement were not, all of them were not adhered to, those that were undertaken. Who didn't uphold their principles that they had signed up to? That's okay, it's just telling us question time starts, so there's no votes. But I'm interested to find out who's to blame, because I haven't been able to establish either from the Minister or assessors who actually was to blame for not upholding this 2010 agreement. And let me just on the record say, I appreciate you weren't the Director General, you weren't involved in it, and I certainly wasn't involved in it and didn't agree to it and condemned it at the time. But we live in the reality of where we are in terms of where I've got to here and where you are in your position, so I appreciate that you weren't party to it and you're dealing with something that came before you, but nevertheless, who was to blame for not implementing the 2010 agreement?
Well, we've been absolutely clear that the prisoners threats against staff, and particularly the murder of David Black, were the clearest breach of the agreement, and that is what has prevented us moving forward, and that's what made it appropriate for the Ombudsman to request of the Minister that that a stocktake be carried out. So I'm not. I hope that's the answer to your question. I'm not absolutely sure I understood the question, but.
Well, obviously, looking at the timeline of events that's usefully put into the stocktake, July 2010 we had this agreement. Then we had commencement of a further protest in May 2011, and then you had the murder of David Black in 1st of November 2012. So obviously you had this agreement from July 2010. The protest didn't start for almost another year. So why then was the agreement not fully implemented by the prison service in that 10-11 month period that obviously prisoners would say led to them having to go on a dirty protest?
I mean, I can't rewrite history of what happened over the entirety of that 4-year period. And if we're looking at where was the agreement not fully implemented, look no further than the actions of the prisoners, not the organisations who would ally themselves to some of the prisoners for the callous murder of David Black. But it's not true to say that it was one-sided. The fact is, NIPS did give a commitment within the 2010 agreement that says we will continue to review and assess ways to further progress supervised free-flow movement of prisoners. And we've been called out on that by the stocktake report that says you made that commitment, and where are we?
Well, with then this agreement in 2010, the vision that was meant to materialise a result of it, and you had then the protest, you had then the murder that took place, you have the ongoing threats that exist and are real. The stocktake is a recommitment of an agreement that has already failed. And so now you are the Director General, and you're not responsible for what happened in 2010, but you are responsible now, and you have accepted these recommendations, which is predicated on a process that is flawed and rewards bad behaviour. So why are you not taking the control that you say you have, that it is all with the prison service? Why are you endorsing something that is clearly shown to have failed in the past?
Well, the stocktake is exactly what it says. It is a stocktake, and it is our opportunity to give some momentum to the process via which we can reach a more normalised environment in the separated accommodation, which will be safer for our staff, which will be more effective in terms of running a well-ordered and safe regime for everybody. So, as I've said before, we need to give that process some momentum. We do believe that there is commitment from all parties now to move towards a more normalised environment. So my job, our jobs as leaders of this organisation is to pursue that goal of a more normalised environment. But we continue to affirm that this is a high security prison environment. We are not talking about ceding control. We're talking about moving from having 3 prisoners on a landing at any time to ultimately to having 6 in 6 months' time, but that is still a very controlled environment. It is an environment which we believe can be safe, which will be manageable. So we're not talking about moving to 24-hour unlock. We're not talking about staff coming off the landings. We're talking about something which will remain very well controlled, an appropriate level of security for a high security facility with Category A prisoners in it.
And do you accept that in continuing on with a failed process, that what was said earlier from the assessors, that this will put the prisoners on the back foot, it'll remove any further excuses, it will take away their oxygen? Do you expect the prisoners to now accept even what's recommended in stocktake, set aside all of their demands that was in the conditions document. Is this the end game, which has been offered to us as a panacea? Is this the end game as far as the prisoners are concerned, or do you anticipate that they're going to come back for more?
We're not setting out to put prisoners on the back foot or to deprive them of oxygen. We're not about that. Our job is to run safe, secure and decent prisons, and we will continue to treat all prisoners in our care decently and properly. So this is not about scoring points over prisoners. We have all the authority. It's not an equal relationship. This is not about depriving prisoners. It's not about trying to catch them out. This is about trying to move towards a more normalised regime within the separated accommodation. So it's about modelling those sort of behaviours, allowing our standards of decency and humanity to prevail, but continuing to run a high security prison facility in which the public can have confidence, and in which we as prison officers of the prison can continue to believe that we're behaving properly.
Finally, in terms of the prison officers' involvement in the outworkings of this stocktake, what has been the engagement with the actual prison officers that are involved in Roe House, and obviously wider, because David Black didn't work in Roe House and yet he was targeted? So it isn't just the staff in Roe House that obviously have concerns about this, but we heard a little bit earlier about what would appear a failure back in 2010 to engage with prison officers directly on this. What has been your engagement with the prison officers on this issue, and where does the Prison Officers Association stand in respect of this stocktake recommendations?
Okay, I'll let Paul talk in a moment about consultation more generally, because he does the bulk of that consultation. But I think it's important to say that we run an organisation which has staff, as we've said, working at the front line, and we engage with those staff regularly and consult with those staff regularly. But our job, our task, and the task of the Governor is to lead this organisation and Maghaberry Prison respectively. So the idea that every individual who is working on the front line with prisoners can be consulted and their opinions sought about everything that will affect them is unrealistic, and it is our job as leaders to make some of those decisions on their behalf. But I've said before that all of us as a senior team engage regularly with our colleagues at all levels, and we spend time in prisons talking to staff, and also have more formal processes for talking to the POA. Indeed, sitting here with us today is an officer, one of my colleagues from Highbank Wood, who is spending the day with me in return for a day that I spent with him at Highbank, just trying to foster better understanding across grades and between headquarters and our establishment. So we remain committed to doing that. But sometimes we have to make some of these difficult decisions about what is best strategically, and to be able to stand above some of the day-to-day issues, to be able to make those decisions. Paul?
The Governor's got two roles, and it's an incredibly complex and demanding role for them to perform. The first is to show leadership, and it's their name above the door, and they're responsible in law for all that goes on within a prison, and they're answerable for that, and that requires leadership, and that requires them to make the big calls when they need to be made, and that will explain what was happening in 2010. But to run an the key part is the second part of their role. You know, these are also huge organisations. Maghaberry is a prison that employs close to 800 people. It's a business that's got a budget of nearly £50 million, and for a business like that to run and to run effectively, then the Governor has to ensure, and the management team have to ensure, that they've got proper communication strategies in place, the ability to listen to what frontline staff have to say, the ability to communicate with unions to ensure that tensions are understood and are managed. And in that respect, the Governor of Maghaberry has ongoing commitments to meet with the POA. That's done on a formal basis. POA also have access on an informal basis if there are measures that are pressing. They have measures to deal with other trade unions through the Whitley Council, and more importantly, if you're looking at the staff in Row House, there are forums for staff. So on a regular basis, the staff from Row House have the opportunity to meet with senior management, and that gives them the opportunity to receive and to share feedback. And the most recent one of those meetings took place this week. So it is something that has been happening with regularity, and it allows the decision makers to ensure that they're fed into what's happening and what the feeling is from staff in their prisons. But this isn't a matter of terms and conditions that we would go to a union formally about and say, could you sign up to? That's not the role of the union. But it's important to understand how staff would feel.
And I accept it's ultimately for management to be signing up to whatever the operational decisions are going to be, and staff shouldn't be able to hold any organisation to ransom. But you've pointed out, Paul, you do need to bring your people with you. You need communication strategies. You need to hear from them exactly their concerns. But for many years, we have heard of the disconnect between frontline, rank and file, governor grades, and Dundonald House. And that isn't something that's new. It has been there historically in the organisation. And whilst I accept the Governor ultimately has to sign on the dotted line, in an organisation where culturally it has been Dundonald House that has been involved in these strategic decisions, it's Director General level who can then has to support governors or not. And if you're not getting that support as a governor from your management, who may have a particular view, but legally it's for the Governor to sign off on, it can be, I would say, challenging. Not impossible, but challenging for a Governor to go against the prevailing view of the senior management at Dundonald House.
And can I just say on this one, it wouldn't be the Governor that would make the final call on accepting stocktake recommendations, but the Governor's voice would be there at the table, telling us what their management team feel, telling us what they're sensing in the prison and the best interests of the prison. But that we can't remove ourselves from the fact that it's been recorded that it's a very controlled environment that exists within Row House and Bush House. You would expect that in conditions of high security. But everything we do is evidence-based. Yeah. And if you look at every piece of empirical research that's been published from 1968 onwards into the regime for long-term prisoners in conditions of maximum security, it tells you that you cannot just rely on control, that you have to work to normalise conditions, to engender dynamic security. And that's what we're trying to do, and we think the stocktake gives us that opportunity.
Just to be clear then, in terms of the prison service agreement of these recommendations, how far down the chain of command did you get support? Obviously, Director General, your directors. Did the Governor approve this? And was the Prison Officers Association asked for their input? And what was that?
We certainly have engaged with the Governor and his senior management team in terms of accepting the recommendations. So they are understood and accepted. And we're absolutely clear about that.
No, just so I'm clear, they understand the recommendations and they accepted the recommendations, or they accept your acceptance of them. Well, does the Governor's team in Maghaberry sign up to?
Absolutely, yes, absolutely, right. Okay. Absolutely. In terms of seeking agreement from the Prison Officers Association, as Paul says, that would not be. It would not be the requirement to consult with the POA would be around things that affect their terms and conditions. So we would not formally consult with the POA in terms of accepting the recommendations. We would talk to them about them, as did the assessors as part of their stocktake. but there would not be a requirement for the Prison Officers Association to sign up to accept the recommendations.
And did the governors talk to the POA, particularly in Maghaberry, and get their view on it?
There are routine mechanisms for gathering feedback and for the POA to share their concerns. But I would have been surprised, actually, if the Governor had formally tabled a meeting to say, I need your approval over this and I want to consult with you over this. But there are regular opportunities, formalised meetings, where staff and their representatives can share their concerns. They would have known the stock take was going on. It was announced. But that's not our only method of communication.
Absolutely.
What's more important are the forums that are taking place with staff. The fact that the Governor grades involved in Row House will sit with their staff, on a regular basis and take their pulse, understand what's happening.
Okay. Mr. Elliott.
Chair, thank you, and thanks very much for the presentation. Just notice outstanding issues from the report. It says ongoing abuse of staff, threats to staff, and it goes on to highlight some of the issues. And then in the state of compliance, one of the areas is, or one of the paragraphs, any relaxation of the present restrictions would depend on the prisoners acting in good faith and refraining from actions that might prevent staff carrying out their work professionally, free from harm, intimidation or threat. I'm assuming if that paragraph is not met, all other aspects are off.
Yes. So, going back to what we've just said, we have demonstrated by making the first move to a more normalised environment that we are committed to achieving the aims set out in the stocktake. So it is now important that the prisoners demonstrate that or cease subjecting our staff to any threats or intimidation.
So you've made a move while there were threats ongoing. So you've made a positive move towards the prisoners while threats were ongoing.
But having made that first move towards normalisation, we now have a clear statement from the prisoners that they are committed to moving towards the aims set out in the stocktake.
So you went beyond what the recommendation of the report was?
No, I don't believe we have.
Well, you accept it with me. Sorry, so you accept it.
Since we've Tom. Since we've made that first move, there have been no further threats to or intimidation of our staff. I mean, it's very early days. Yeah. I'm not counting any chickens, but we have to make that first step. And should there subsequently be any threats or intimidation, we're then in a different place.
Okay, but the point is, you did make the move while the threats were still in place.
Well, the threats and intimidation we're talking about on Row House are the day-to-day physical intimidation of our staff. So there have been none of those threats or intimidation since we made that first move.
The stocktake reports on an impasse. We recognise there is an impasse. We believe that the prison is safer and more secure if we can normalise conditions, and somebody needs to put momentum into this. So we took the first step.
Yeah.
Okay.
But that's both internal and external. How do you adjudicate when the external threats have been lifted?
Well, we can only respond to what happens subsequent to our making that first move, and we will do that.
Yeah, how are you going to deal with the external threats, though? Who's going to advise the prison service that obviously you'll get your internal information, staff will be able to very easily relay that to you, but the assessor's report has said these recommendations should only be implemented whenever the threat, both internal and external.
I mean, I wouldn't expect you to expect me to talk in this forum about those mechanisms. If I'm reading your question correctly. Yeah.
Well, I'm trying to understand how we're going to have public confidence that you're not moving ahead to appease the terrorists whenever one of the conditions are that the external threat also needs to be raised. So how are we going to know? If the public are going to have confidence in this relaxation in the regime, then I think we need to know the criteria that's going to be used to adjudicate on how conditions are actually being complied with by the prisoners.
Absolutely, and that's what we've set out, if we have any indication that threats to our staff, either from inside Maghaberry or externally, are continuing, then we review our position.
Sorry, Tom.
Yeah, Chair. How long is it from you took that initiative to relax some of the measures?
Well, I'm sorry to be pedantic, but we would prefer not to talk about relaxing the measures, but we're moving towards more normalised environment. That was yesterday, day before?
I believe it started 2 days ago. Yes.
2 days ago. Okay, and there's been no threats from within the prison those 2 days?
The feedback from the prison is that so far things are working well.
Okay.
It's early days, and it's something that we'll be assessing and staying very close to. But I think we needed to give this momentum. I think it's a positive step towards normalised conditions. Normalised conditions offer our staff safety and ensure that security isn't compromised.
Are there any more? And sorry, I may not agree with your term around normalisation, because normalisation for dangerous prisoners may be different to me, or I may have a different view on it to what others have or those prisoners have. But anyway, I'll use your term for the sake of it. Are there any other steps towards that normalisation planned in the near future?
Well, the next step is to see the establishment of the prisoner forums. And we hope that the prisoner forums will be the vehicle with which positive developments ensue within Row House. But in terms of normalisation, I don't think it's just a case of my opinion. CGINI and HMIP in 2006 and in 2009 talked of unnecessary restrictive arrangements for the movement of separated prisoners. In 2013, they echoed that and said security arrangements on the separated units remained overly restrictive, and it was also alluded to within the OWA's report. So it isn't just my opinion on this matter, it's something that's widely shared.
Totally accept that it may be within that criminal justice system, but the wider public may have a different view on it, the same as I have.
Yep. Okay.
So I think we'll agree to differ in that. So the next stage is the prisoner forums, and when's that planned to be established?
Well, the next requirement is that we identify an independent chair, which we'll try to do as quickly as we can.
Okay.
Is that not the International Red Cross? Have they not been flagged up as?
They were suggested as a possibility.
Certainly have leanings towards relaxing the regime.
They would have been suggested, but we're continuing to have the conversations.
I think some of us may question their neutrality in respect of the type of regime that others would think is appropriate there.
Yeah, we understand that.
Sorry, just finally, Chair, on that point, who will be on, sorry, forgive me for mentioning this, but who will be on the prisoners forum? Is it only prisoners?
It's the prisoners and representatives from the management. So you would typically, correct me if I'm wrong, Paul, get the senior officer would attend the governor grade who has responsibility for Row 3 and 4, either the unit manager or the functional head, would attend and has previously chaired the forum, and then any officers who are on duty would attend. So it's staff and prisoners.
Thank you. Thanks, Chair.
Mr. Free.
Yes, thank you, Chair. I apologise if I ask questions already been asked, because I had to nip out for a few minutes. I want to talk about the practicalities of some of these measures, and in particular the one with regards to increasing the number of prisoners on landings from, at the moment, 3 up to 4 as a goodwill measure, and then ultimately up to 6. Now, any relaxation, I'm quoting from the Stocktake report, any relaxation of the present restrictions will depend on the prisoners acting in good faith and refraining from actions that might prevent staff carrying out their work professionally. Now, if by increasing by increasing the number from 3 to 6, and something happens that prevents staff from carrying out their work professionally, how then, so the agreement's broken, how do you roll back in Row House?
Well, I think first of all we do exactly what we've done, which is to set out a very clear message that any movement from 3 to 4 and indeed beyond that is predicated on no threats, no intimidation and no instances where prisoners are preventing our colleagues on the landings from going about their duty. So we determine how many staff are on duty on each day, and we determine how many prisoners are unlocked at any one time. So every day is a new day. So we could start again each day if I think that's what you're asking.
Well, can you move then if you go from 3 to 6 and something breaks down, something happens, and they prevent your staff from carrying out the work professionally? How then can you roll back from 6 back down to 3?
Well, I don't see how we can.
In reality, I think, as Director General said earlier, the fact is we have the power. We hold the keys and we define what the regime looks like. But we like to act in good faith because good faith generally brings with it good order within prisons. So that's the goal, and people like to behave accordingly. But the process of rolling out this particular recommendation within the stocktake is being stage managed. We are giving it momentum by moving to 4. The stocktake advises us to move to 6.
Yeah.
The Governor and his team take the view that this is something that they will see step changes for over the period of the 6 months. So if in 3 months' time there has been improvement, they'll look to increase it towards 5, 3 months later to 6.
Yeah, but the time difference isn't the issue in my question. The question is, if you get to 6 or 5 or 4, and something happens, the whole agreement breaks down, how do you get back to 3? Because that was a condition of the agreement.
Yeah, absolutely, and I think it's you're right. It is a practicality. I mean, we've said before that when we talk about the landings and we talk about the controlled movement on the landings are essentially a transit area from the cells to the communal areas, where there aren't the same restrictions on numbers because prisoners are in a secure area. So I might be being dim here, Paul, and I might be missing the point of your conversation, but we determine how many prisoners we unlock at any one time to transit that landing to get to wherever they want to be. And it is in prisoners' interest to comply with that because they want to be either in the rec room or the classroom or the exercise yard. So we can determine, because as Paul says, we have the keys and we have the control, we unlock 3 at a time or we unlock 4 at a time.
Well, sorry, it could well be me that's being dumb. So you're telling me that is a mechanical movement or action?
Yeah.
That won't require any more staff?
No. It's the same number of staff. It's just an increase in by 1 in the number of prisoners that are unlocked at any one time to transit the landings to get to the
So that is basically a mechanical action that will move you down to 3 immediately?
Yes.
So you can take away that liberty if you like? Immediately?
Yes.
Right, okay, sure. Thank you.
How many threats would need to occur for you to go back to your default position and reduce the numbers out in landing?
Well, there are two answers to that. I mean, we've been very clear that all of the movement is predicated on an absence of threat. So 1 threat is 1 threat too many. But we've said before, running prisons is a tricky business, and we routinely deal with failure to comply, with challenges to our authority, with poor behaviour on a continuum. So I think it would be for us as professionals to make those judgments, or for the Governor, supported by us, to make those judgments about what was safe, as he and his colleagues do on a daily basis.
Because once you move beyond 1 threat is too much, then there's an acceptable level of threat. and it becomes subjective based on your dynamic risk assessment and so on. But this stock take says it'll only go to 6 if all of these conditions are met. And unless you're absolute in respect of that, then you only encourage them to come back for more, and they will inevitably test the boundaries. So I want it very clearly spelled out. How many threats will mean it goes back to square one? Everything's taken off the table. You've got the keys, you've got the power. The prisoners aren't going to be able to dictate their terms, and you go back to reducing the number of people on the landings. How many threats?
Well, we would be absolutely clear that all of this progress, it requires good faith and an absence of any threats. So one threat is one threat too many, and is not acceptable under any circumstances.
Mr. McCartney.
Thank you very much, Chair, and thank you very much for your answers to date. I mean, I know you were there when the assessors were there, so I'm not going to go for the preamble, except to say that I think there is an opportunity, but there's also obviously challenges which face everybody in relation to this. Can I ask you, is there anything in the stock document which you feel you can't deliver?
Well, we've accepted the recommendations, so we've been clear that there is obviously the final recommendation is one for the Secretary of State and the Northern Ireland Office. Yeah, of course. But other than that, we believe it all makes for a move to a safer environment for our staff and a more normalised environment.
So, I mean, there's nothing in the stock take that undermines or jeopardises security?
No.
Far from it.
No.
Okay. In relation to, I mean, there was both the Chair, I think, alluded to this. In terms of the discussions with staff, senior managers, and obviously staff right down to, there has been no formal discussions around the stock take?
No formal consultations.
Has the POA made any formal submission to the governors or to yourselves at administration level?
Well, the POA continues to talk to us about staff safety generally, as you know, but in relation to this, no, I don't think they have.
No, I'm not aware of any.
No?
And neither would I have expected it to be the truth.
No. So you wouldn't have expected that they would have a position in relation to this?
I fully accept that they will have opinions, and they will want to reflect the opinions of their members, and if they didn't feel that the Governor was capturing those through his forums with staff, they would want to step into the gap.
Okay, and we talked about the independent chair. What's your timeline for someone being in place and the first forum taking place?
As soon as possible. We've got a meeting this week. We've got a meeting this week to talk about that. So as soon as possible.
We all use as soon as possible.
Well, we'd like, you know, we'd like it to be in place within. We'd like to identify somebody within the next few days and approach them.
So if it run on for 4 weeks, you would consider that
too long.
Acceptable?
Yeah.
Okay. And in terms of, I mean, in terms of monitoring the stock take, obviously, I mean, the independent assessors seem to suggest that they'll have some role in this, right? Have you a view how this should be assessed from your end of things and from the prison end of things, or will it be joint or separate?
Well, I think it would be most helpful if the assessors continue to have a role in monitoring this, because that does give it that independence and that credibility from all interested parties and stakeholders. But that sitting alongside that is Paul's routine management visits, where he routinely visits Roe, the formal mechanisms for talking to staff and through the POA, and visits from other senior managers. So I think the formal mechanisms for giving assurance to the Minister would be through the independent assessors, but we would also anticipate being able to pick up very quickly if there were any difficulties with it, so that we could respond to those.
And is there someone specifically tasked for that, or is that just going to be a broad sweep?
That would be a matter for the Governor, I think.
This falls under that category where it's too important for anybody to ever let it slip. Yeah. So it's meat and grist for virtually every conversation I have with the Governor of Montgomery. I wish I could talk to him about other matters, but this particular issue is one that needs resolution if we are to serve the interest of the other prisoners in Montgomery too.
But I'm just sort of, the reason why I asked that, says a misinterpretation of a particular aspect, and at the beginning, if you reflect back to August 2010, that became one of the issues. You know, what did this mean, and what did that mean? And so someone has to be on top of this, or it can fritter away by misinterpretations. If it's left to a governor, then it should be left to a governor. But if it should be left to someone else, then it should be their responsibility to say, what's this about? And here's the definition. And how do we get the definition? How do we come to an agreement what the definition is? So if there's no process for that, this can...
Okay.
And the reason why I say that, because I've made this point to all our Director Generals, is that too often there's a prism, and the prism can be, this is a return to Long Kesh. You know, despite the fact that Long Kesh is closed and in mothballs at present. But that can create a scenario where anybody who makes anything that seemed to be what you call normalisation, then the throwback becomes, oh, that's a return to Long Kesh, so therefore that has to be seen as a bad thing. You know, and sometimes even when people talk about a return to Long Kesh, it can be through a very partial prism, because our people can talk about a return to Long Kesh about that were bad practices on our aspect. So what I'm saying is, there has to be a mechanism in place that this is a process of normalisation, of having a regime which at its core is about being humane and dignified and respectful to everybody, and it's not blocked by, if you like, a false prism. Okay, thank you.
Okay, Mr. Pitch.
Why was it your role to move first?
Because, as we've said, we are the people that run the service. I think it's important that it's our responsibility to deliver this and to give it momentum. So I think that was wholly appropriate.
I'd have to strongly disagree.
Okay.
It's not your responsibility to be caving in to pressure. Over the course of this time, we have witnessed the murder of a prison officer. We have had 2 prison officers who have viable devices sent to their homes, and they've had to move from their homes. In the course of the last few days, sinister comments have been published on a Republican website about 4 of my colleagues. And in the last week, Mr. Cockwell, Republican Network for Unity named a senior prison officer official, and that has been condemned by Finlay Spratt of the POA. But in spite of one of your prison officers being named last week, when there's no demonstration of goodwill whatsoever coming from Republicans, you're caving in and giving concessions to them, and that is not acceptable.
We've been clear that naming our staff is totally unacceptable, and we work...
So we give them more concessions the following week? We go down a train of concessions the following week after the naming of staff when you say it's unacceptable?
Well,
what authority do you have, Ms McAllister, in those circumstances? The prisoners are laughing at you.
It is our responsibility to run the prison service and to run secure, safe and decent prisons, and part of that is to deliver the recommendations that we've accepted, and we're absolutely clear that everything we've done so far is appropriate, everything we've done is defensible, and everything we've done is to move towards an environment which is safer for our staff.
Our incentive for moving first was the prize was greater for us. The fact is, nothing that will come about from this stock take will compromise security within what is a high security facility. But by normalising the regime and the dynamic security that should bring, that's currently missing, will make it a safer environment for our staff. The prize is too rich to decline.
Can I ask you what level of drug use, not the prescribed drugs, there is in the prison?
Yep, at the last Justice Committee hearing, I gave out detailed figures, and I believe that pitched it. I
I mean, we haven't come here prepared to talk about drugs.
But it should be pretty, you should have that just off the cuff. I think that's not an unreasonable question to ask.
And I think
there's a context to it.
I think I laid out at the time that it was in the region of 17%, and I laid out the significant reductions that had been achieved over the past year.
Okay. If you have that scale of drugs imported into the prison, what else can be imported into the prison? Could explosives, for example, can be brought in and very fine materials be imported into the prison?
I think that's a really important point, and Paul can come in a moment. When we talk about searching, we have been clear that currently we have not identified a technological alternative to full body searching. We've tested millimetre wave body scanners. We've sent somebody down to Portlaoise to look at the multi-mode threat detector. We've sent off an application to use X-ray scanners. We know that technology is evolving all the time, and when and if there is something that is as good as full body searching, we will consider that. But there's nothing at the moment. Now, nobody likes full body searching. Nobody likes carrying out full body searches. Both Paul and I, I'm sure, have done more full searches than we would have liked to have done. Prisoners don't like them. They're unpleasant for everybody. But we remain clear that Maghaberry is a high security prison. In part, row 3 and 4 is a high security facility, and that is why we continue to carry out full body searches. We've always said it is possible for items to be brought into prisons in a variety of ways, including internally, and we do not carry out intimate searches. We do not search in people's body orifices. So, of course, it is always possible. We just have to make it as difficult as we can, and we do that through good searching, through good intelligence, and through blocking the routes insofar as is practically possible to stop unauthorised items of any type coming into our prisons.
So do you want to? Are you confident there are no lethal weaponry in the prison?
We heard what was mentioned already. There is a requirement if any of our staff have any information that suggests that there is anything unauthorised in the prisons, there is a requirement on them to inform us of that immediately through security information reports or through other means. Failure to do that is a breach of the Code of Conduct. So if there is information that our staff have and it's not being passed on to us immediately, then we need to address that. Given that has been mentioned here, we need to go away and look at that immediately, and we may have to come back to the people who mentioned it in here to seek more information, because that would be very worrying if that information was out there.
Well, if that information existed and it was shared with prisons authorities, if it wasn't shared, it's a breach of somebody's code of conduct. If it was shared with prisons authorities, there is an immediacy to how that would be handled. It would be red flagged. It would be analysed quickly, the threat would be assessed quickly, and if action was needed, action would be taken quickly to respond to it. But we are not passive when it comes to security. This is a high security facility, and nothing will change from this stock take that will compromise security, except we may benefit from dynamic security that's currently missing. We've spent £11 million upgrading the security within Row House. 1.2 million recently. We're upgrading the search facilities for goods coming into the prison and people coming into the prison. And we've invested a lot of time in improving the procedural security around Maghaberry. We are not complacent when it comes to security. These are Category A prisoners, but we recognise that we need to normalise the regime. And the prize for normalising the regime is that normal interactions will in the future run between staff and prisoners, and that will allow us to capture dynamic security, which is currently missing.
You see, we have a history in Northern Ireland, and you, Mr Cockwell, referred to empirical evidence. And I would remind you of a proverb which says there's nothing new under the sun. And how Republicans are behaving at this current time is not new. Republican prisoners in the past behaved like this in the maze, which led to an outcome which was wholly unacceptable in terms of how a prison was managed, and we should never, ever ever get into that position in Maghaberry. And there is an absolute fear amongst both prison staff and the wider public that the concessions that are being made are concessions that will take us to the same place as the maze. And, you know, you're saying that's not going to be the case. We're not going to wake up some morning and switch off from what you currently have in Maghaberry to what you had whenever the maze was closed. It was done incrementally. And the evidence that we're having at this moment in time is that whenever Republicans misbehave, then they get concessions. Then they turn the tap off, and for a period of time, then you get more misbehaviour, you get more concessions, and incrementally, bit by bit, you denude the security regime that exists. That's the empirical evidence that there has been throughout the history of prisons in Northern Ireland, Mr. Cockwell. And that is something which we as public representatives will not allow the Minister or indeed the prison authorities to go down again.
I think you've identified a really helpful pointer for us that, as Paul says, we are absolutely clear that in the last 2 years we have strengthened the security in our prisons. We've strengthened the physical security by investing money. We've strengthened the procedural security by being absolutely clear with our staff at all grades of what they need to do. And we continue to strengthen dynamic security, and this is one way in which we're doing this. But what you do identify is that we may need to get better at educating and communicating so that people understand why we're doing things, and that actually the things that we are doing will strengthen security rather than dilute it.
Thank you, Mr. Chair. I had no confidence in the previous people who addressed this committee, and I think that they're being used by the prisoners as useful idiots, and consequently you should be very careful in the advice that you're receiving from them, because that will not play well with many people in the public who have an expectation that prisoners are kept in a secure environment, that prison officers can carry out their duties safely, and that concessions should not be made to people who murder, who send viable devices, who threaten people. They should not be receiving concessions.
Okay, I've just one last question, and just a bit of clarity. Mr. Elliott had mentioned when the clock started ticking, and if I'm right in saying it's from 2 days ago in terms of this agreement. Was that right?
That was in terms of moving to 4 on unlocks on a landing.
I'm just trying to get clarity that there was the stocktake report that was released, and then you had the naming of that Senior Prison Officer Association official that night. So if one threat's too many and you're opposed to prison staff being named, one might be able to say that they've already breached the agreement. Yep. So I'm trying to get clarity as to when you believe the clock started ticking for prisoners' compliance. Otherwise, I would expect you to renege on your gesture of goodwill to prisoners that you've already committed to, based on what happened.
Okay. Well, we can go and satisfy ourselves with that timeline, but we are clear that it was incumbent on us to make the first move, and that's what we've done. And
I ask you to review the time frame of when this stocktake was announced and the Republican Network for Unity's press statement, where they named a number of people, but they named one of your members of staff. Mr. McCartney?
On a broad point, obviously people here have different views and different perspectives, but I think that people come in front of us in good faith should be treated with courtesy.
Can I thank you both very much for coming to the meeting? Our next committee meeting, members, is tomorrow at 2 o'clock.